Hi, I'm Daniel Finling with Finling Law and thedivorceguy.com. And in this webinar, part of the Michigan Divorce Education Series, we're going to discuss planning for divorce. Whether you're the dependent spouse or primary wage earner, there are things that I can share with you to help you in the divorce process. A good place to start is simply why get divorced? Well, maybe you've fallen out of love. Maybe there's been infidelity. Maybe there's a mental health concern that one party won't address. But a primary basis for divorce is one party simply is not happy. Now, I'm not going to be able to help you with the decision whether you can divorce or not, or whether you should divorce or not. But certainly this webinar is going to help you plan if you've made the decision to divorce. What should you be thinking about? What should you be doing? The decision to divorce is not easy, but there are really three choices. You can do nothing. You can work on the nature of the problem with a therapist, provided, however, both parties are willing to work on the nature of the problem. Or you can get divorced or a divorce alternative like a legal separation. In Michigan, we call that a separate maintenance agreement or a post-nuptial agreement. Think prenuptial agreement, but after you're married. Now, all three of these decisions, doing nothing, going to therapy or working on the problem, or a divorce alternative, are good decisions depending upon the facts and circumstances. What's right for you and your family? However, in this webinar, we're going to focus on the notion of the decision has been made. That is, you're going to file for divorce, which begs the question, is it important who files first? And as a general proposition, the answer is no. Oftentimes you'll hear a lawyer describe to you why you should file first, and I'm suspicious as sometimes that's just a sales pitch. Let's talk about the circumstances which filing first may make a difference. Well, there are a few instances when filing first can make a difference. If you're worried about a dissipation of the marital estate, somebody's going to be spending money, or you're concerned about cash flow, by filing first, we can get a financial status quo order and a mutual restraining order regarding property transfer. We can get these entered after the divorce filing, but sometimes it's a little bit later. So if you're worried about dissipation, that is somebody selling all of the assets, or about being able to pay your bills during the divorce process, then filing first and getting these orders entered may be important to you. Sometimes there's jurisdictional concerns. I want to file first because I want to have the case in Oakland County, for example, versus Washtenaw County, or even California for that matter. But probably the most important reason to file first has nothing to do with the legal concern, and it's emotional. Should you be proactive in life or reactive in life? Being proactive means you're doing something, being a plaintiff. Being reactive is a defendant. Now, from a legal standpoint, in most circumstances, does it matter who files first? No. But here are the exceptions that we just discussed. But I am a big believer in being proactive in life. So I'm going to discuss divorce planning for both spouses, the dependent spouse, and the primary wage earner. When thinking about both spouses, something that everyone needs to be concerned with is having an understanding of what there is to divide. What is the nature and extent of the estate? And there's various mechanisms by which a lawyer can do that, through a verified financial information form, which we're required to exchange after filing, or other types of discovery. And I discuss this further in a webinar called The Formal Process. But you should copy documents, copy your tax returns, your deeds, your wills, and so forth. Have these available for your lawyer, because during that consultation, it's going to help the lawyer address with you how a proposed division may look like. It's important to videotape the contents of the home. It's not uncommon for things to disappear with the emotional level being high after filing for divorce. And most importantly, create a cash flow analysis. That is, what are your monthly expenses? What is it going to cost you to continue to live with the fixed income that's available when parties are divorced? And obviously, you need to sit down with a qualified attorney, set goals and expectations. So a divorce plan for the dependent spouse. What do you need to think about if you are counting on money from your spouse? Well, oftentimes we'll get a financial status quo order and a mutual restraining order regarding property transfer entered, which provides that Your spouse has to continue provide you with money as they have in the past, and no one can sell or encumber property during the course of the divorce proceedings. And because we have these restrictions, sort of like maintaining things as the way they were, if you have an important purchase that needs to be made, you may want to make it before these orders go into effect or before a divorce is filed. Don't quit work. Oftentimes a dependent spouse is going to feel or may feel that if they quit work, it's going to better their spousal support claim. It usually doesn't work that way. You're usually better off from a cash flow standpoint having both spousal support and income from employment. If you have debt that's in your own name, for example, you owe your sister money, and it has nothing to do with a marital debt, that's something that both you and your spouse may be responsible for, it's a good idea to pay that off before filing or find a mechanism to do that. And of course, don't move out of the house. Now, I'm going to put an asterisk there. You're going to hear this a lot in terms of other lawyers saying don't move out of the house. I say it's okay to move out of the house under certain circumstances. But when should you not move out of the house? You should not move out of the house if you have child custody concerns and you're not going to be able to move with the minor child. Because if you move out of the house and the child remains with the other parent, it may cause problems down the road. And I don't want you moving out of the house if there's not enough cash flow, if you can't afford to move out of the house. But certainly if it's affordable and we don't have issues regarding a child, that is, you can take the child with you and move out of the house, or if there's domestic violence and it's really just for the safety of the client, then I will advise you that it's okay to move out of the house. If you're the primary wage earner, there are certain things that I want you to consider as well. First is to avoid suspicious activities. I'm talking about things like transferring property shortly before you filed for divorce by maybe a quitclaim deed, or rewriting the beneficiaries on your life insurance policies. The majority of cases settle, and there are a lot of things that a qualified lawyer can do to help the primary wage earner prepare and minimize their exposure. However, if there's no trust and confidence, if suspicious activity is discovered and revealed, then it's going to really complicate things and make the case more expensive. If you have cash that's on the side and you can keep it aside, well, that's okay too. In terms of your mail, the dependent spouse is going to be putting on a detective hat, trying to determine everything that they can. So if you have mail coming to the house with maybe things you don't want your spouse to see, it might not be a bad idea to have that mail sent maybe to work or somewhere else. I do not like or advise clients to pay off debt, because when you're the primary wage earner, this debt is marital. So when it comes time to negotiating your case, whether it's through settlement or ultimately at trial, in the instances when a case goes to trial, when there's debt that's marital in nature, it reduces the exposure for the primary wage earner. After all, the dependent spouse generally can't pay the debt. So we use that as a mechanism by which the primary wage earner pays the debt and we get something in return. If you have bonuses or income that's deferred, or you're worried about a pension vesting, it may be a good idea to file for divorce before the pension vests, before you get bonus, or before you get supplemental income. Always important to create a cash flow analysis, understand where your money is going and how it's being spent, because certainly the dependent spouse is going to be doing that, and we're going to want to be able to compare from a spousal support standpoint, what is it going to take to maintain a lifestyle, and are they overstating what the monthly expenses are? And of course, it's important to set goals and expectations early with your lawyer and then work on those goals. All right, you've made the decision to file for divorce, and now you want to know if you can date, or maybe you're engaged in an affair. What should you do about it? Well, the first bit of advice I'm providing is don't do it. Well, there's two paths for a divorce. There's a legal path and there's an emotional path. Your lawyer is best equipped to help you navigate the legal path. That is, what's the business decision of divorce? What are we going to be doing in the best interest of the minor child or children, as the case may be? But if you're engaged in an extramarital sexual context or an affair, and the other spouse finds out about it, even after the filing for divorce, it could stir up enough emotional energy that makes it difficult or impossible to resolve your case without going to trial. Now, if you are, use discretion. I would prefer you don't, but if you do, use discretion. Don't even tell your best friend if you can avoid it. And certainly don't tell your spouse. The only person that feels better when they admit to their spouse that they've had extramarital sexual contacts or an affair is the individual confessing, because you're taking your guilt and you're placing it now on your spouse. Unfortunately, that also exasperates things because now emotions are running higher and your case becomes more difficult to resolve. It's a good idea to keep a journal. It may just be notes, but you get the idea. If custody and parenting time are at issue, having a journal regarding what are the doctor's names, right? What are the children's schedules? What are the name of their friends, school? When is your spouse exercise parenting time, not exercise parenting time? These things in a journal will help refresh your recollection. Also, this notepad that you're keeping or journal, ask questions that you want to discuss with your lawyer that you're worried about. Oftentimes you have a meeting with your lawyer, you discuss your goals, and then you go home and you're up at 3 o'clock in the morning worried about A, B, C, D, E, F, and G, whatever that may be. If you have that notepad or journal next to you, then certainly you can write these things down, raise them with your lawyer, and get answers. Your lawyer is a tool that you use to help achieve your goals. Don't forget that. Your lawyer is a tool. They work for you to achieve your goals. What a qualified lawyer is going to do is share with you what they believe the court's going to do in fact. What are your options? How do they maximize what you're going to receive in the divorce process, or minimize, as the case may be, what you might have to pay? And that's our job, to give advice. It's a good idea or a bad idea, but we don't make decisions. We give advice. Clients make informed decisions to the benefit of their lawyer and their lawyer's skill set and experience. Keeping a journal is a great way to keeping tabs on everything. Now, it's inevitable that you're going to have questions. I just really skimmed the surface of what you need to think about in terms of a divorce plan. Through a confidential consultation, we can provide more insight as to what's important to you in your circumstances and help provide you comfort moving forward on how to best protect you during this process. I'm Daniel Findling with Findling Law and thedivorceguy.com. This is part of the Michigan Divorce Education Series. I'm very proud of it. I've been working on this series for well over 10 years. There's dozens of videos and hundreds of thousands of views. I want to invite you personally to contact my office at 248-399-3300 if you have a question. Toll free at 877-YOUR-FIRM, YOURFIRM, or of course email me at daniel@findlinglaw.com. That's FINDLINGLAW.com, or visit our website at thedivorceguy.com. Let it be our privilege to help you.